Hello, good morning and welcome to this webinar. Thank you very much for giving up your time to attend. It's a nice sunny morning here in Lincoln's Inn, and it's a great pleasure to be speaking to everybody who's online this morning. So the format of this is as follows. I'm going to be speaking, my name is Peter Dodge, as no doubt you may have gathered, and I'm going to be speaking for about 40 minutes. And after that, there will be an opportunity for you to ask the questions. There's a Q&A icon at the bottom of the screen. So if you wish to ask a question, just type your question in there, and assuming we have time to deal with it, then I'll attempt to do so at the end of the webinar. For anybody who is inclined to take notes, please don't. There's no need to do so because you will be receiving, or will be available to you, a PDF of the contents of this webinar. And when we finish, the screen will show the contact details and how you can get in touch with us and obtain a copy of the PDF if one doesn't automatically arrive. And there's also another paper which I delivered about a year ago, which I'll be referring to in the course of the webinar. So if you'd like a copy of that, again, look at the contact details, which will appear on the screen at the end of the webinar, which hopefully will be in about 45 minutes time. So I won't be taking up too much of your time. But to begin with, I should say that this webinar is about risk. It's about the insurance of that risk and the court's approach to apportioning losses arising from that risk. And the risk is one which would have been familiar to any 19th century contract lawyer. What if A believes himself to be contracting with B, but his counterparty is in fact a fraudulent imposter impersonating B? Now, the title of the webinar is 7 Years On for Dreamvar, the Evolution of Property Fraud Litigation. And in a sense, that topic is somewhat elusive. The number of decided, let alone reported cases in which Dreamvar has been mentioned, considered, followed, or distinguished is relatively small. That's not, though, because Dreamvar provided all of the answers. Like many leading cases, it sets out the legal principles, but leaves plenty of scope for argument as to how those principles should be applied in different factual circumstances. Rather than being litigated at trial, claims may be settled on the basis of the parties' perceptions of how the court would be likely to apply Dreamvar. And in this webinar, I'll be sharing some of my perceptions by way of various practical conclusions. Now, it was in May 2018 that the Court of Appeal, Lady Justice Gloucester, Lord Justice Patton and Lord Justice Floyd, handed down judgment on two conjoined appeals, P&P Property Limited against Owen White and Catlin LLP, and Dreamvar UK Limited against Mishcon de Rea. But for the solicitor's profession and its insurers, the cat had been set among the pigeons over a year earlier by the first instance judgment of Mr. David Railton, King's Counsel, sitting as a Deputy High Court judge in the Dreamvar case. How, asked the profession, can a non-negligent firm of solicitors acting for a bona fide purchaser in what turns out to be a fraudulent conveyancing transaction, how can that firm be liable to its client for a loss caused to that client by the fraud of a third party? And the answer to that question lay in the exercise by the trial judge of two discretions arising under Section 61 of the 1925 Trustee Act, a provision giving the court power to relieve a trustee from personal liability. And by way of reminder, that section reads as follows: if it appears to the court that a trustee, whether appointed by the court or otherwise, is or may be personally liable for any breach of trust, but has acted honestly and reasonably, and ought fairly to be excused for the breach of trust and for omitting to obtain the directions of the court in the matter in which he committed such breach, that's the first discretion, ought fairly to be excused, then the court may relieve him either wholly or partly from personal liability for the same. That's the second discretion. So ought fairly to be excused, then the court may relieve him. Two different discretions. Now, Mr. Railton, King's Counsel, declined to exercise those discretions in favour of the non-negligent firm of solicitors, Mishcon de Rea, which had acted for the bona fide defrauded purchaser, Dreamvar, and he declined to exercise those discretions for three reasons. And first and most strikingly, he said this: as for MDR's position, it's common ground that it is insured for events such as this, and that its insurance cover is sufficient to cover in full the loss suffered should it not be excused from liability. In terms of balancing the relative effects or consequences of the breach of trust, it's apparent that MDR, with or without insurance, is far better able to meet or absorb it than Dreamvar. And secondly, that was his first reason. Secondly, he regarded it as not irrelevant that a professional firm such as MDR was, as he put it, necessarily far better placed than its lay client to consider and, as far as possible, achieve greater protection against risk. And thirdly, at least at first instance, the Court of Appeal overturned this aspect of the decision, but at first instance, Dreamvar had no recourse against the non-negligent firm and against the non-fraudulent firm solicitors, which had had the misfortune to be instructed by the purported vendor being a fraudster impersonating the true registered proprietor. There was no practical likelihood of Dreamvar being able to trace the purchase monies or to make any recovery at all from the fraudster. As a result, at that point, at first instance, the only practical remedy it had was against MDR. Now, this reasoning has little, if anything, to do with the identification of wrongful acts or omissions, which is what litigators spend a lot of time attempting to do. Little, if anything, to do with that, and everything to do with the apportionment of risk. And I'd make three preliminary observations. First, the proposition that insured professional trustees are better able to absorb losses than their lay clients and better placed to anticipate and head off potential losses isn't specific to conveyancing transactions. This could be applicable to any application for relief under Section 61, or for that matter, its equivalent in other jurisdictions, such as Article 45 of the Jersey Trusts Law. Second, my second preliminary observation, I'm not qualified to express a view as to the pricing of professional indemnity insurance. But this type of insurance is generally regarded as intended to cover the risk of malfeasance, misfeasance, or non-feasance on the part of a profession. It's not intended to cover commercial risks, such as counterparty risk, in relation to the underlying transaction. And whilst the Court of Appeal gave the Law Society permission to intervene by way of written submissions, it nevertheless had before it no data as to the potential effect on professional indemnity insurance premiums of the first instance decision. Thirdly, I accept that there is a public policy interest in maintaining the integrity and reputation of the retail conveyancing market, with it being undesirable for participants to be seen to be losing large sums of money through fraud. I don't suggest that the risk of such losses shouldn't be insured at all. The question is whether, as a matter of the principled application of Section 61, they should be borne by professional indemnity insurers. Now, whilst I can't comment on the current market for such products, purchasers themselves can insure against various risks, including the commercial risk of counterparty fraud. And a collateral benefit of that type of purchaser insurance is that insurers are likely to insist on some sort of searches or inquiries being made as to the identity of the insured's purported counterparty, the person who's claiming to be the registered proprietor, the seller. If, say, a developer purchaser wishes to save the premium on such insurance and take on the counterparty risk himself, it seems to me that that's a matter which could and should be relevant to any exercise of the Section 61 discretion. Now, in the Court of Appeal, Lord Justice Patton, with whom Lord Justice Floyd agreed, described the conclusion of Mr. Railton KC in the Dreamvar case. Remember, there were two cases, Dreamvar and PMP, as unimpeachable. But he also had to consider the question of whether relief should be granted to the solicitors which had acted for the purported vendors in the P&P case. In doing so, he referred to what he described as the strict approach to professional trustees, which had been adopted less than 3 years after the coming into force of Section 61 by the Court of Appeal in re Windsor Steam Coal Company, 1901 Limited. That strict approach, he said, finds an obvious counterpart in the need to have regard to the effect of the breach on the beneficiaries. Beneficiaries here being the solicitor's clients, the frauded purchasers. He cited with approval the words of Lord Justice Briggs in Santander UK plc and RA Legal. Relief under Section 61, said Lord Justice Briggs, is often described as an exercise of mercy by the court. In my judgment, the requirement to balance fairness to the trustee with a proper appreciation of the consequences of the exercise of the discretion for the beneficiaries means that this old-fashioned description of the nature of the Section 61 jurisdiction, an exercise of mercy, should be abandoned. In this context, mercy lies not in the free gift of the court. It comes at a price. So that price is, of course, derived from the question, if a client solicitor's professional indemnity insurers are not required to indemnify the client, well then who will? How will the client be indemnified? How will the client be compensated? And yet, even post-Dreamvar, I don't think it can be said with any degree of certainty that a professional trustee will necessarily be denied Section 61 relief in any particular case. First, the Court of Appeal had upheld the granting of relief in Santander, the case in which I just cited the dicta of Lord Justice Briggs, and it had granted relief in Nationwide Building Society against Davison solicitors, albeit in both of those cases, the beneficiary which stood to be disadvantaged by the grant of relief was a financial institution which might have been thought capable of bearing the loss. Secondly, in Dreamvar itself, Lady Justice Gloucester delivered a powerful dissenting judgment on the issue of Section 61. And she said this, I don't consider that the fact that MDR is insured should, in the circumstances of this case, lead to the conclusion that MDR should bear financial responsibility for Dreamvar's loss. Dreamvar was entering into what was for it a relatively substantial property development as a business transaction. I don't consider that the court sympathy, which should be with one commercial party, in reality with its loan creditors, given its insolvency, rather than another, simply because one and not the other has insurance. It's irrelevant, in my view, that Dreamvar was a newly formed company or that its beneficial owner was a young man. So the practical conclusions which I draw in relation to Section 61 of the Trustee Act are as follows. One, the decision in Dreamvar is not limited to fraudulent conveyancing transactions. It's a potential application in any case where a trustee, particularly a professional trustee, has acted honestly and reasonably, as MDR had. Second, two, it's hard to avoid the conclusion that the wind is blowing against the grant of relief to professional trustees who carry insurance. But the dissenting judgment of Lady Justice Gloucester in Dreamvar provides principled support for the proposition that it shouldn't be regarded as a given that relief will always be refused. It would be unfortunate and potentially unjust if a perception were to develop and to influence settlement negotiations in cases which don't proceed to trial, if a perception were to develop that a particular type of defendant will always be refused relief simply because he carries insurance. 3, whilst in the words of Lord Justice Briggs, relief comes at a price, it should be remembered, a fact not really addressed by the Court of Appeal in Dreamvar, that refusal may also come at a price for a non-negligent solicitor in terms of having to fund an excess, in terms of having to pay higher insurance premiums in future. 4, it's also hard to avoid the conclusion that whenever an issue arises as to the applicability of Section 61, both claimants and defendants, whether insured or not, will need to consider whether to adduce evidence, seek disclosure, or both, as to, in the words of Mr. Railton, King's Counsel, the relative effects or consequences of the breach of trust. Put bluntly, the court may find itself in the position of having to conduct an unedifying form of financial means test in order to determine who should bear this type of loss. Now, moving on, for Section 61 to be potentially engaged, there must, of course, already have been a finding of breach of trust against one or both of the purchaser's solicitor and the firm purportedly acting for the true owner. As Lord Justice Patten identified, the agreed starting point must be that in the hands of his own solicitor, purchase monies are held on a bare trust for the purchaser pending completion. The authority for that is Target Holdings and Redfern, a case in which Lord Justice Patten had himself appeared for the lender claimant. And over the years, that case was decided in the mid-90s, and over the years, the starting point led to an appreciation that, for the reasons explained by Lord Justice Reimer in the 2012 case of Lloyd's TSB Bank PLC and Mark and Dan and Uddy, where a purchaser's solicitor pays away the purchase monies or mortgage monies other than as part of a genuine completion, where there is no genuine completion, that payment away is likely to constitute a breach of trust. He's likely to be held to have been in breach of trust. Now, this led some of us to question why, if a purchaser's solicitor would be in breach of trust by releasing the purchase monies on the purported completion of a transaction, which is in fact a nullity, why the purported vendor's solicitor, who after all is the person best placed to assess the genuineness of his client, why he too shouldn't be equally liable when paying away those purchase monies purely on the strength of the purported completion, which is in fact a case of fraud, no completion at all. The first example of a purported vendor solicitor being held liable came in 2014 with the first instance decision of Deputy Master Jeffries in Puran Singh and the Court and Co. Now, the effect of the decision of the Court of Appeal in Dreamvar was to endorse what many people had perceived all along to be the status quo. MDR had conceded liability for breach of trust, accepting that its instructions had not permitted it to release the purchase monies except on completion of a genuine sale and purchase. Of course, here the completion was not genuine. There was no genuine completion. In both the PMP case and the Dreamvar case, the firm acting for the fraudulent imposter, the vendor solicitor, was held to have been in breach of trust. Its authority to release the monies to its client depending on there having been completion in accordance with paragraph 10 of the Lord's Society's Code of Completion by Post, 2011. This meaning the completion of a genuine transaction for sale. Fraudulent completion, is not completion at all. Now, it might be thought that the effect of this is that conveyancing transactions are now effectively underwritten by the various solicitors' professional indemnity insurance. If there isn't genuine completion, both the purchaser's solicitor and the purported vendor's solicitor will be held to have been in breach of trust, and there'll be limited prospects, as I've already described, of obtaining Section 61 relief. So take the case of a developer purchaser. Often developers are prepared to buy property which is in some way tainted because they believe the risks to be reflected in the price. On the analysis which I've just described, the commercial counterparty risk would in reality be no risk at all. If the purported vendor turns out to be a fraudster, well, both solicitors' professional indemnity insurance will pay out. If, as sometimes happens, the purported vendor's solicitor is implicated in the fraud and his insurer declines cover, that's not a problem. The purchaser's own solicitor insurer will simply pick up the entire tab. However, that analysis seems to me to be both erroneous and potentially dangerous. It ignores the fact that Dreamvar is not authority for the proposition that where there is no genuine completion, liability for breach of trust will automatically follow as night follows day. The reason for this is that the basis of liability for breach of trust when wrongly paying away trust money is lack of authority. In Dreamvar, MDR accepted that its instructions were not such as to authorize it to release the purchase monies other than on a genuine completion. Now, it's hard to envisage circumstances where a purchaser would authorize his own solicitor to release the purchase monies or authorize the purported vendor's solicitors to pay away those monies, knowing the purported vendor to be a fraudulent imposter. But what about the case of a commercially astute purchaser who's aware of the risk of impersonation, has assessed that risk, and has nevertheless decided to take the risk, presumably because the deal is sufficiently attractive to justify doing so, taking that risk? Why, as a matter of equity, should the solicitor's professional indemnity insurance be required to underwrite a risk which a commercially astute purchaser has voluntarily chosen to run? Now, one point didn't arise in Dreamvar. There are dicta in the judgment of Lord Justice Patten which support the proposition that the mere fact that a transaction is fraudulent will not necessarily lead to a finding of breach of trust. As he noted, the ultimate question to be decided is whether the point when the purchase money is released by the vendor's solicitors to his client, the solicitor has the authority of the purchaser to make that payment, even if the transaction is not a genuine sale. So this expressly contemplates the possibility that a vendor's solicitor may have authority, even if the transaction is not a genuine sale. The question being, does he, in fact, have that authority? And as Lord Justice Patten went on to note, it was held in target that the circumstances under which a solicitor can part with money from client account are regulated by the instructions given by his client. They're not part of the trusts on which the property, the purchase money in client account, is held. As a default position, in the absence of express authority, the client may be assumed only to have authorized parting with that money for the purposes of a genuine transaction. However, where the client's considered the risk that the transaction may not be genuine and has authorized his solicitor to press on regardless, the position may and arguably should be different. Now, Mr. Jeremy Cousins, King's Counsel, who appeared in Dreamvar, has kindly reminded me that in Barclays Bank and Weeks, Legg and Dean in the late 90s, Lord Justice Millett noted that a solicitor who had given an undertaking that mortgage monies would be applied solely for acquiring a good marketable title was authorized to disperse such sums in accordance with that undertaking. And Lord Justice Millett went on to hold that the undertaking was not absolute in its effect, but merely imposed a qualified obligation on the solicitor to obtain what a reasonably competent solicitor acting with proper skill and care would accept as a good marketable title. So as long as the solicitor did that, he was complying with the undertaking and he would have authority. As a matter of general impression, rather than objective statistics, in the 7 years since Dreamvar, it's become more common for purchasers and their advisors to consider and assess the risk that a proposed transaction may not be genuine, especially in the case of transactions which involve what are described in the Law Society's practice note on property and registration fraud as vulnerable properties. That's unoccupied properties, tenanted properties, high-value properties without a legal charge, high-value properties with a legal charge in favour of an individual overseas, and properties undergoing redevelopment. That list is not necessarily exhaustive. It seems reasonable to suppose that in a significant number of such transactions, for example, properties undergoing redevelopment, the purchaser will be a developer rather than a standard owner-occupier. Now, a purchaser, even a sophisticated developer, is entitled to sit back and rely on the purported vendor solicitor having undertaken all necessary checks as to his client's identity. You can sit back and rely on what somebody else has done. But as Sergeant Wilson in Dad's Army might have said, do you think that's wise, sir? The practical conclusions which I draw in relation to breach of trust are as follows. Again, the decision in Dreamvar isn't limited to fraudulent conveyancing transactions. It's a potential application in any case where a solicitor holds money on client account with authority to pay that money away for the purpose of a particular transaction. 2, it can't safely be assumed that in every case where a transaction turns out to be fraudulent, the tab will be picked up by the solicitor's indemnity insurance. There are principal grounds for arguing that where a purchaser, in particular a sophisticated commercial purchaser, has chosen to take on a risk, he must bear the consequences of that risk. 3, Dreamvar type cases are an example of the relatively unusual phenomenon, of which more later, of clients being able to sue someone else's solicitors rather than just their own. As such, there are potential issues of confidentiality and privilege which don't arise when a client merely sues his own solicitor. A purchaser may take advice from his own solicitor, make a conscious and informed decision to authorise completion, despite the fact of the risk of the transaction being fraudulent. But what though if that conscious and informed decision, of which the purchaser's solicitor is aware, is never communicated to the solicitor purportedly acting for the vendor, who could also be potentially liable? This is where the issue of confidentiality and privilege can arise. 4, since Dreamvar, purchasers and their solicitors find themselves in something of a quandary. Whilst in theory, a purchaser may be entitled to rely upon the purported vendor solicitor having made all necessary checks as to his client's identity, in practice, the purchaser's solicitor may be vulnerable to criticism if he fails to advise his client of the risk of fraud, and also as to the desirability of making his own checks. But making such checks and deciding to proceed regardless may, though, create an opportunity for insurers to argue that, in the words of Lord Justice Patten, the solicitor has the authority of the purchaser to make that payment, even if the transaction is not a genuine sale. The purchaser has thought about it and decided to go ahead. How common is all of this, though? 7 years on, the type of fraud encountered in Dreamvar, referred to by HM Land Registry as registered title fraud, shows no sign of abating. According to the Land Registry's own website, in the year to March 2024 alone, it stopped, that's its word, stopped, 97 registered title fraud attempts on properties valued at a total of £58 million. I've tried to seek confirmation of this, but I've seen that the word stopped in this context refers to a refusal to register a transfer on an application made following purported completion, meaning that the purchase monies are already likely to have been dissipated following the purported completion. Then there's the application to register, then that application is stopped and refused. Now, the Land Registry has a financial interest not only in the prevention of fraudulent sales, but also in interception of such sales before registration. As to prevention, it encourages registered proprietors to consider signing up to its property alert scheme and to consider applying for a Form LL restriction. This restriction is not dissimilar from the requirement in some other jurisdictions for notarization of property transactions. a disposition won't be registered without a certificate signed by a conveyancer that conveyancer is satisfied that the person who executed the document submitting for registration of the transfer as disponor is the same person as the proprietor. That's the requirement of an LL restriction. As to interception, the registration of a fraudulent sale is likely to amount to a mistake within the meaning of Schedule 8 of the 2000 Land Registration Act. If the disposition is forged, that disposition will be void, and the registration of it will constitute a mistake, regardless of any knowledge or lack of knowledge on the part of the registrar or the true owner, the purported transferor. The true owner may be entitled to have his name restored to the register. The jurisdiction to alter the register to correct a mistake, the rectify, is in Schedule 4. In the event of rectification, event of the true owner being restored to the register, the innocent buyer, the Dreamvar, if you like, may then be entitled to be indemnified by the registrar pursuant to Schedule 8. But on the other hand, if the fraud is spotted before registration, perhaps by the Land Registry, there will be no entry to register, to rectify. The entry will never be made, and thus there will be no entitlement to be indemnified by the registrar. The defrauded buyer will be left with whatever remedy he may have against his own solicitor, against the solicitor acting for the purported seller, or a combination of the two, those including the breach of trust remedies subject to the availability of Section 61. So just as HM Land Registry has an interest in the interception of fraudulent sales before registration, both firms of solicitors and their insurers have a financial interest in ensuring that transactions are registered as soon as possible. If the buyer then turns out to have been defrauded, the solicitors and their insurance can argue that he should have recourse in the first instance to his entitlement to a statutory indemnity. Now, I'm very happy to supply on request a copy of a paper which I delivered in September last year to the British-German Jurists Association, which analysed the point in time at which the fraud was spotted in various, as a matter of fact, in various cases, including Dreamvar itself. But as the Land Registry figures indicate, it's not uncommon for frauds to be spotted before registration, after purported completion, but before registration. That's good news for HM Land Registry, and it's perhaps less good news for solicitors and their professional indemnity insurers. Now, time allows me only briefly to mention two other types of fraud in property transactions, which may lead to litigation. In the first half of 2024, UK Finance reported over 1,100 cases of what it calls invoice and mandate scam, a form of authorised push payment fraud. And these cases included criminals targeting consumers by posing as conveyancing solicitors. Here, the most significant development has been the coming into force in October last year, 2024, of the UK's authorised push payment fraud reimbursement scheme. There will, though, be cases which fall outside the scope of that scheme. In particular, it doesn't apply to international payments or to payments which take place across payment systems other than the faster payment system, FPS, or the clearinghouse automated payment scheme, CHAPS. Also in the field of financial services regulatory law, there continues to be a significant volume of litigation arising from ventures involving numerous individuals being persuaded to invest in the development of a particular property, often as a hotel or some form of leisure resort. Now, such a venture might amount to little more than a fraudulent Ponzi scheme. Whether or not that's the case, though, ventures of this type may constitute collective investment schemes within the meaning of the Financial Services and Markets Act 2000, collective investment schemes which have been sold and distributed in such a way as to avoid compliance with the quite strict requirements of Part 17 of the Act, and which thus have been sold and distributed and promoted unlawfully. I'll conclude by saying something about the three common law causes of action which were considered in Dreamvar That's negligence, breach of warranty of authority, and breach of undertaking. And those interrelate with the breach of trust cause of action, which I've already discussed. Turning first to negligence, now this is an area where the decision of Dreamvar has been subsequently considered by the Court of Appeal and distinguished. Dreamvar affirmed the general rule that solicitors don't owe a duty of care to parties other than their own client. In Ashraf and Leicester Dominic solicitors, a property owner claimed to have had the single misfortune of being defrauded not once, but twice. And the second fraud was said to have involved the alleged forgery of his signature on a transfer which was submitted for registration, submitted to the Land Registry, by a firm of solicitors acting for a lender. And that transfer was submitted under cover of a form known as AP1. What that form AP1 requires to do is it requires the person submitting it to provide certain confirmations. And the Court of Appeal held that it was arguable that when completing an AP1 form, the conveyancing solicitor making the application, in this case was the solicitor acting for the lender, was acting for all parties and therefore owes duties to all parties. Lord Justice Nugee said this: leading counsel for the lender's solicitors submitted that the purpose of the Land Registry insisting on such confirmation was for its own benefit, in that if it unwittingly possesses a false instrument, it may have to pay out under its statutory indemnity. But it seems to me well arguable, and this was only a question of an issue of strikeout, well arguable that it is also for the benefit of the true proprietor. The Land Registry is not a commercial business simply looking after its own interests, but a public body whose purpose is to provide a service to those who want to engage in land transactions. Identity fraud is a known problem in this area, and it's in the nature of things likely that the applicant will be acting for the transferee, or as in this case, chargee, seeking to have themselves registered, whereas the likely victim of any fraud will be the true registered proprietor. In those circumstances, I'm far from persuaded that the confirmation is only for the benefit of the Land Registry, not for the benefit of other parties concerned. Now, again, the significance of this decision isn't limited to cases of conveyancing fraud. It was an application for what Lord Justice Nugee called the Al-Kandari principle, the principle that solicitors can owe a duty of care to non-clients when they've stepped outside their normal role. So the general rule in Dreamvar, no duty of care, but there can be exceptions to that. Also of wider application is the decision of the Court of Appeal in P&P on the issue of where the solicitors and the estate agents purportedly acting for the vendor in that case, whether they were liable for breach of warranty of authority. The outcome in P&P is somewhat complex and it's fact sensitive. What the Court of Appeal held was that by executing and exchanging the contract on behalf of the seller, the fraudster solicitors adopted the terminology of the contract. Inherent in the solicitor signing the contract on behalf of the seller was a warranty that she acted for the true owner. Conversely, though, the estate agents have merely given a basic warranty of having instructions to act for the purported seller, whether he was the true owner or not. So two different strengths of warranty in the same case. As between, on one hand, the solicitors and on the other, the estate agents. Where the claim against the solicitors fell down, however, was in the lack of inducement or reliance. And if it's right that since Dreamvar, purchasers and their solicitors are making more inquiries of their own as to the true identity of their counterparties, it may be increasingly difficult for them to argue that they relied not on the inquiries which they've made themselves, but on an implied warranty given by the firm purportedly acting for the vendor. As in the case of a solicitor's authority to pay away the purchase monies, the scope of the trust, this may be another example of the making of wise and prudent inquiries, potentially having unintended and unfortunate consequences. If you make inquiries, you've got to get it right. In many ways, the most important aspect of the judgment in Dreamvar involved the construction of the undertaking given by a seller's solicitor under what was then paragraph 7 of the completion code, an undertaking which must be given in probably the vast majority of conveyancing, certainly retail conveyancing transactions which take place day after day. This was important. The decision on this was important not only because it was this that led to MDR obtaining a complete indemnity, MDR, the non-negligent purchaser's firm of solicitors, but also because it resulted in the revision of the code itself, a new edition of the code being published post-Dreamvar in May 2019. However, this is the topic about which I propose to say least, because it is specific to conveyancing transactions. Lord Justice Patten construed the code as meaning that in both PMP and Dreamvar, the firm of solicitors acting for the purported vendor gave an undertaking that they had the authority of the real registered proprietor to receive the purchase monies on completion, not the person who purported to be the proprietor had the authority of the real registered proprietor. I've only got 4 comments on this. One, the drafting of the revised version of the code isn't without its ambiguities, but it seems tolerably clear to me that insofar as it was intended to give effect to the decision in Dreamvar, that revised version of the code should be construed as a limited undertaking as to identity, and not any sort of wider undertaking as to the title which the purchaser will receive. 2, the drafting of the revised version of the code is principally addressed at bilateral transactions. Purchaser, vendor, purchaser, buyer, seller. How should it apply, for example, to subsales, which the notes to the code itself expressly recognise may require particular care? 3, since the decision in Dreamvar, it doesn't seem uncommon for correspondence in conveyancing cases to include discussion of the code undertaking. Now, the danger of attempts to paraphrase in correspondence the express wording of the code means what it means, but attempts to paraphrase that in correspondence, the danger of that is that it may give rise to arguments that the effect of that correspondence is to vary the code undertaking. The parties have agreed to something slightly different, or to introduce additional, stronger undertakings, which aren't there in the code at all. And 4, in terms of enforceability, I would just observe that the decision of the Supreme Court in Harker Sinclair LLP and Your Lawyers Limited post-dates Dreamvar, and that has potential ramifications for the summary enforceability of solicitor undertakings generally, including the code undertaking. So to conclude, it's a satisfying feature of Dreamvar that it addressed such a wide range of causes of action and legal principles: breach of trust, negligence, breach of warranty of authority, and breach of undertaking. A wide range of causes of action and legal principles, both common law and equitable. Dreamvar's applicability, however, is by no means limited to losses arising from fraudulent conveyancing transactions. What was held by the Court of Appeal is potentially of much wider application in all sorts of different types of case. However, such transactions, the Dreamvar type transaction, the identity fraud, home hijacking, whatever one chooses to call it, such transactions do continue to occur, and claims arising from such transactions continue to be threatened, issued, and settled. So there seems no immediate prospect of this possibly narrow but rich seam of litigation being exhausted. I hope that the session has been useful. Thank you very, very much for attending. Thank you very much for listening, as you have been, and so I hope it proves useful to those who have attended.